So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right? Good morning. Are you Nasir Brown?
I'm not here today on special appearance.
I'm sorry, speak up so I can hear you.
Here today
You're appearing here today?
by special appearance.
Okay, what is your name?
I'm a third party
And here we go. If you've watched Courtroom videos before, you probably recognize this strategy. Some defendants believe that refusing to identify themselves or claiming they're a separate legal entity somehow strips the court of its authority. But in reality, judges have heard these arguments countless times, and they almost never succeed. The longer this goes on, the thinner the judge's patience becomes.
Third party intervener was behalf of artificial legal entity, not separate.
Okay. At one point in your, at some point in your life prior to being this third party, were you Nasir Brown?
No,
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nasir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown.
Notice how quickly the judge shuts that argument down. Subject matter jurisdiction isn't something a defendant can simply reject by saying a few legal-sounding phrases. If the court has authority over the type of criminal case and the alleged offense occurred within its jurisdiction, the case moves forward. That's why the judge doesn't spend 5 minutes debating it. She simply rules and keeps the hearing on
I'm going to
track.
call you by Mr. Brown because I'm not going to say all the words that you just said because you've now identified yourself as Nasir Lewis Brown. And so, Mr. Brown, this is your initial appearance and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very patient.
I had the challenge subject matter jurisdiction going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with
This is actually an important moment. The judge isn't trying to punish him here. She's giving him a roadmap. Hire an attorney, or at least show you've made a genuine effort. It's a reasonable court order, and ignoring it later could have serious consequences. Remember this moment, because it's about to come back in a big way.
With the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer? Speak up so I can.
Up and down.
It's been up and down?
Yes.
Okay, so here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge
The
different.
whole overstand versus understand debate might sound clever, but legally, it changes absolutely nothing. Courts care about whether a defendant comprehends the judge's instructions, not which synonym they prefer. In fact, constantly arguing over word choice can distract from the issues that actually matter and frustrate the court.
They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand? I'm sorry,
Overstand.
say it
They
again.
overstand.
You overstand?
Yes.
Okay, what does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'll block.
You'll
Block.
oblige.
I'll block. Yeah.
Okay. You just determined to use different words than and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay, and so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out your bond would be raised and you would go back to jail. Do you understand that as well?
Overstand.
You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, step in front of the clerk. Nasir Brown. Are you Nasir Brown?
I'm sorry. We were here before.
You've been here before, but you have to speak up where I can hear you.
Executing beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose
Yes.
hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the cop. I do have.
Take the glasses off. I need to see your eyes.
And
Please.
there it is, the consequence the judge warned about from the very beginning. This wasn't a surprise ruling. The court gave clear instructions, explained what would happen if they weren't followed, and then enforced that warning. Whether you agree with the defendant or not, this is a reminder that ignoring court orders can quickly turn a manageable situation into a much more serious one. What would you have done differently in his
Stop. I need to see
position?
your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your two cases. Did you get a lawyer hired?
Asterisk, by
Good
the end
shot,
of this
too.
hearing, the legal issues have almost taken a back seat to the defendant's behavior. Instead of focusing on defending the actual charges, the courtroom became consumed by arguments over identity, jurisdiction, and compliance. That's a lesson seen again and again in court. Cooperation doesn't guarantee victory, but refusing to follow lawful court orders often creates even bigger problems than the case itself. Let me know in the comments. Was the judge patient, or did this situation escalate exactly the way you expected?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rife. What's his name? Rife King?
Mm-hmm.
What's his name again?
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt. Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of a lawyer that's in this state that I'm not fond of. This is formal name.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because I say, you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started.
Don't make me lay hands on you,
Why would you lay hands on me?
because you're not doing it. I'm telling you now, go.
Mr. Brown, you need to go back with the bailiff. Right now, I've raised your bonds You have to go with the
I am
bailiff.
not a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are
I
hands
told
being
you,
put
I
on?
told you I was gonna put hands on you.
Why are hands being put on? Y'all see this on the camera?
And right there, put your hands on the wall. Okay, put your hands on the wall, because you're not listening. Don't listen. I don't advise that.